clients will often say to me that the court and the prosecutor are not going to waste their time with the client's case. So often the client will be charged with a misdemeanor, or maybe he's charged with a felony, but the facts of the felony show that it's not very serious what happened. And in the defendant's mind, the prosecutor and the courts are very busy with very serious crimes, and they're just going to eventually become exasperated and dismiss the defendant's case. So I assure these clients that that will not happen. And I believe the client's naive idea that the court will just drop the case because it's not serious. I think it comes from three sources, really. Number one, the defendant fails to understand that he's dealing with government and not a private entity. So the government cares less about efficiency and about resources. A private corporation is going to be less likely to waste resources and is going to care much more about efficiency. That's not the case with the court system. Number two, the defendant fails to realize that the people at the court and at the DA's office probably don't know anything about the facts of his case. Right? The defendant assumes that everybody knows the facts and the details of his case as well as he does, and they all know, like he knows, that this isn't serious and that it shouldn't be prosecuted. That's a mistake. Right? The people at the court probably don't know anything about the details of your case. And then number three, the defendant fails to understand the sort of assembly line nature of the criminal process. So the way the pretrial works, you go there with your lawyer, and the prosecutor will be at his desk, and he'll have probably a couple dozen folders in front of him with cases in them. The defense lawyer will go up to the prosecutor and say, "What are you recommending for my client?" And it's only then that the prosecutor will take the defendant's file and give it no more than 2 minutes of consideration and say, "I'm offering whatever it is, guilty, 1-year probation, a quaff with conditions," and that's the recommendation. The prosecutor is not going to budge. The defendant can either make his own recommendation to the judge and hope the judge accepts it, or take the case to trial. And you have to be aware that no matter how frivolous your case is, if you take it to trial, the prosecutor will show up and he will prosecute it. He's not just going to throw up his hands and say, "I'm too busy for this." All right? So the court and the prosecutor will waste their time on your case, and you need to realize that. I've written a blog post on this, and I'll put it in the description below.